We're still got some time left before the starting time. What's the size of a quorum? All of them friends, except one.
因為我仲要過隔離。而家我哋係進行。
This is a meeting of the Bills Committee on Private Healthcare Facilities Bill. We have to elect a chairman. Please refer to Rule 21E and Appendix 4 to the House Rules. We need to have a nomination seconded by at least another member to be valid, and the nominee must also accept the nomination before we proceed. Mr. Chen Hang-ban, seconded by Mr. Wong Ting-kwong. Do you accept the nomination, Mr. Chan? Yes. Do we have another nomination? No one is willing to nominate Tommy Zhang.
有冇提名？上一次好似係。
Do we have another nomination? Last time someone counted 1 to 3. Should I do the same? 1, 2, 3. We don't have a second nomination. I declare Mr. Chan Han-ban elected as chairman. Congratulations. Let's get it done in one go.
唔使，我哋慢慢審噶嘛啲嘢。我想問下大家需唔需要選副主席
？Members, do we want to elect a deputy chairman? Does anyone think that we need to elect a deputy chairman? No? Thank you. Let's invite the officials to join us.
好啦，咁我去到呢度啦。咦，跟住冇噶咯喎。選噶喎。paper 嘅冇 chairman brief 係嘛？有冇啊？我冇 chairman brief。唔該晒。我 members list。好我哋而家請咗政府官員入嚟，我哋或者請阿
invited the administration to join us. Mr. Sun, over to you for an introduction. Yes, I will give an introduction to the bill. In Hong Kong, private healthcare facilities comprise many different privately owned facilities providing medical services. To cope with the ever-changing development of this sector, the government has conducted a review on laws regulating private healthcare facilities. We have the view that the current scope of regulation is too narrow and the regulation system is outdated. In the past few years, we have experienced a number of medical incidents related to these facilities, leading to a lot heightened public concern. So through the public consultation and based on the views received, we have come up with this new bill, which is called the Private Healthcare Facilities Bill, to take the place of the current Hospitals, Nursing Home and Maternity Homes Registration Ordinance and the Medical Clinics Ordinance. Let me now go over the key features. First, types of private healthcare facilities to be regulated. Under the bill, there will be 4 types of public healthcare facilities, or PHF, which would be required to be a license. And they are hospitals, day procedure centers, clinics, and health services establishments. They are all defined in the bill. In respect of clinics, since medical practitioners we call them small practice clinics are operated by doctors. Small practice clinics can be the subject of an application for exemption from the Director of Health. And for a licensed facility, we have to differentiate two types of persons, the licensee and the chief medical executive. That is to say, the licensee is required to bear the full responsibility for the clinic, and a chief medical executive should be appointed for the day-to-day operation of the clinic, and the bill sets out their functions and duties and responsibilities. And also the private healthcare facility must comply with certain requirements because of public expectations of the bill. In terms of price transparency, we would require a higher level of transparency in Part 5. The licensee has to implement transparency measures on fees and charges, including information on fees and charges for public information, and the licensee has to, in respect of certain procedures, come up with package fees. As for the complaint handling, we propose a two-tier system to regulate to handle complaints about PHF. First, there's the tier for hospitals, day procedure centers, and health services establishments. The licensee of these facilities must set up a complaint handling mechanism for complaints related to their PHF. And secondly, there is also a tier of the mechanism to handle complaints about service providers in this particular field. And the complaints committees can also conduct investigations. And the Director of Health is also empowered to come up with code of practice and amend the regulations. There are different standards to regulate these PHF, which will be promulgated as a code of practice by the Director of Health. The Director of Health and the Hong Kong Academy of Medicine has set up a steering committee to formulate the regulation systems, and they are also working on the regulation centers for clinics. And non-compliance with the required standards can lead to suspension of the license or even revocations. And nursing homes will be regulated under the Cap 459, so that there will be a transitional period to allow them to make adjustments. First of all, we regulate higher PHF with high risk, and that is to say hospitals and day procedure centers. We thank the public and stakeholders for giving us views during the consultation. We have been maintaining liaison and communication with different stakeholders, including we have conducted a public opinion survey. We have organized more than 70 briefing sessions with the stakeholders. Members, we now have a Q&A session. Mr. Alice Mack, 5 minutes. Of course, we would like to get this implemented as soon as possible so as to regulate PHFs. Under the current system, if we are to lodge a complaint, there's no established mechanism for us to do it. And the DOH is only given limited power to regulate clinics and hospitals. But of course, if we have a complaint about a doctor, we can approach the Hong Kong Medical Council, but who knows how many years it will take. But we have no channel to lodge a complaint about service standards and the like. I have a question about paragraph 23, i.e. Transitional arrangements. What's your proposal for these transitional arrangements? You want to make sure that both the public and the stakeholders are ready for regulation. What do you mean by that? Thank you, Ms. Mack, for your questions. With regard to the transitional arrangements, we have made reference to the way we regulate traditional Chinese practitioners. For hospitals and daycare centers, apart from those which are registered under the category of clinics, they are not required to be licensed. For private hospitals, they are already licensed, so it's easier for them to make adjustments. We have 5,500 day procedure centers or clinics. We estimate that there are more than 500 day procedure centers. We need to give them time to allow them to apply for full licenses while not causing disruption to the services. And we need to provide some transitional arrangements so that they will be provisionally registered before they get a full license. For certain clinics and centers, they may be located in premises that would mean that it would take some time to comply with the new requirements, even if they are very willing to do so, and we don't want to cause any service disruption. So we provide the transitional arrangements to maintain the services, and they will be provisionally licensed, and then they will be given sufficient time to be fully licensed. That's the spirit behind these arrangements. How long would the transitional arrangements be like? It's difficult to set a deadline now because we don't know when the transitional arrangements would work out. So the way it is drafted in the bill is that the Secretary for Health and Food can decide on the duration. We need to be flexible so that we can strike the right balance between the needs of the public and the service providers, because they may not be able to meet certain conditions in the short term. So we need to have regard to the actual operations of these facilities before we set a period for the transitional arrangements. We may have some beauty industries services, and they may also employ doctors for some parts of the procedure. We recently had the DR court case. So are these centers required to be registered or licensed? Among those which are being tried in the court, what about these beauty centers which also hire doctors to do Botox injections and the like? Are they required to be licensed? The scope of the regulation would cover the procedures carried out by doctors. But of course, if it's a doctor's clinic and it's a small practice clinic, then it can be exempted. In the case of a beauty center where a doctor is hired to provide certain service, then if it's a clinic, it has to be licensed as such. And if high-risk procedures are carried out, covered by the scope under day procedure centers, it would have to be licensed as a day procedure center. they have to comply with, all of them have to comply with the bill and the regulation requirements.
Mr. Raymond Chan, I fully support this private healthcare facilities bill because indeed, compared to hospitals under the HA, private hospitals are not subject to proper regulation. So I hope that this bill can improve the situation. Recently, I've been following up on the case which is rejected by a private hospital. And in my written question to the LegCo and also at the panel meeting, I have mentioned this case, so I will not go into detail about this case now. My question is, pending the new legislation, say if private hospitals refuse to provide services to patients, my case is that this hospital rejects to provide service to this patient and all his family members, asking him or her not to approach the hospital again. Is it a breach of the law? And ultimately, we may go to the DH to lodge a complaint, and maybe they will be running into difficulties in having their license renewed, if that is the case. But under the new law, I see that you are really focusing on medical problems and procedures. But then for the cases that I mentioned, they may not be covered, say, by the code of practice or what. So can you effectively, say, deal with cases in which private hospitals refuse to provide service to patients without good grounds? Thank you, Mr. Chan, for your question. Indeed, earlier, we have given a written reply to Mr. Chan's question. I will ask Dr. Fong to elaborate on the situation a bit more later. Under the new law, the director will be given official powers to promulgate codes of practice, and that may cover not just medical procedures, but also, say, statements or on patients' rights and so on. So we'll have to look at individual cases. Say if patients have certain views on certain services, maybe they can lodge complaints through the complaint mechanism that I mentioned, and the first tier being a complaint mechanism set up by the hospitals itself. And if that can't be dealt with properly, they can go to this independent committee on complaints with statutory powers. And I think that committee will look at the situation of the individual cases and see how the complaints can be handled. So, Dr. Fong, please. Dr. Fong. The code of practice will require a complaint mechanism be set up, and also hospitals, when they provide their service, they should make sure that they can provide services to meet with the needs of the patients. As to what services are being provided to patients, what matters most is that hospitals should have full regard to the patient's safety. Say, if the hospitals cannot provide service meeting with the needs of the patients, they should explain clearly to the patients concerned, and maybe they can refer other service providers to the patients. And in case of emergency, they may have to make an emergency or urgent referral as well. Now, as to whether appropriate services can be provided, of course, the case that I handled is being treated unreasonably because the hospital said that it will not provide services to the patient and his family members. It will never provide such services. So for that kind of case, will it be covered by the code of practice, or will it be can it only be dealt with, say, by the committee on complaints? Yeah, will you be able to deal with cases where services is refused? Referring to Mr. Chan's case, a patient wants to get the service from the hospital, and for various reasons you think you're not getting the service you want. And if you think that the hospital has not dealt with your case properly, of course you can lodge a complaint to the Committee on Complaints. Now, as to what the ruling will be from the Committee on Complaints, will depend on really the committee's investigation into the case. well, the patient may not approach this hospital again, but then this patient can afford private healthcare facilities. But because he was treated unreasonably, so he would turn back to the public health system, because in the public health system there is a proper complaint mechanism. And so if that is the case, then we will be not be, say, achieving the objective of having some people being diverted to the private sectors for treatment. Dr. Pierre Chan. We welcome this bill, but it involves a wide spectrum of issues. Just now, I went to the Food and Safety FSEG panel. I am asking for a public hearing to be held because the beauty sector may also be concerned about this bill. Please note my suggestions. So that's number one. Quite my questions now. I would like to ask about Annex A, about the list of high-risk medical practitioners which can be performed in day procedures centers. One is about the endoscopy service. And you've got ABC, endoscopic procedure, ABC. Now, if it is not a medical endoscopic procedure, you're talking about Annex A, right, in the document. Sorry, I'm talking about Annex B. Which page are you referring to? So, I'm in a rush, sorry. My whole pile of documents is upstairs. Anyway, I'm asking about the high-risk procedures. Is that okay? That should be Annex A, right? It's within the bill itself. I would like to ask about the high-risk medical procedures. Can Mr. Sun, we can leave it, save it for the day, close by close scrutiny. Well, for endoscopic procedure, there are several items listed here. If it is not therapeutic endoscopic procedures, if you are talking about gastroscopy or colonoscopy, what are you, how are going to be handled? So I'll defer to Dr. Feng to elaborate. Well, how did we come up with this table? This was not done by the DH alone, on its own. There was a steering committee, as I mentioned earlier, set up, and we worked together with the HKAM and the relevant doctors, and then we have 7 expert committees, and one of them dealt with the endoscopic procedure, whether they are considered high-risk procedure. If yes, then that will be incorporated into the annex. So that's how the process worked. We would respect the professional views of the doctors, and as to whether these will fall into the day procedure centers procedures, and we have sought the views of the professional doctors. All right, endoscopic procedures. Dr. Feng, please. For endoscopic procedure, you can see that 2A, well, C has to do with therapeutic endoscopic procedure, and for B, we are talking about endoscopic procedures involving sterile cavity, and so gastroscopy, colonoscopy should fall within this category. Now, we're talking about chemotherapy, and that should be regulated. Now, drip, some of them are dripping procedures on the drip. Well, that's very common on the mainland. And if the drip contains certain chemical substances, will it be considered as chemotherapy? Now, the way it was written was rather broad. Now, if we have the drip and we add in calcium and other chemical substances, will those be covered? Will that be would it be a more detailed description of the chemotherapy here? Now, we're talking about a cytotoxic therapy. So we are not talking about intravenous injection here. Now, earlier, we talked about hemodialysis. I communicated with the administration on that. And Dr. Sun, or rather Mr. Sun, said that there was an expert committee which came up with certain recommendations. But then there were gaps. So what about hemodialysis? We talked about this later last time. Was there any follow-up after that? Thank you, Dr. Chen, for your question. A couple of months ago, through Dr. Chan, we talked to some renal doctors in Hong Kong, and in relation to hemodialysis therapy and how we should be regulating on the premises doing this. Now, broadly speaking, there was some misunderstanding, and we try to explain or clarify the misunderstanding. As to the medical procedures, I'll defer to Dr. Feng. Now, on hemodialysis, on the description of hemodialysis, they wanted us to follow up with a more detailed description. We will be following up with the expert committee in our working group meeting. We will be discussing this as well. Yes, that will be followed up on. Next one, Mr. Chen Kim-po. I'm concerned about price transparency. I would like to ask whether you have a template or format so that there is a standardized format for filling out by all hospitals. And I hope that the information should be useful. Now, I would like to ask how are your talks with the hospitals on that? And also, 90% of the medical expenses being paid by insurance companies. Ultimately, have you talked to the Hong Kong Federation of Insurers? Asking, say, the insurers for their input so that the system can be made more effective, because the insurance companies will know much better, will know very well what types of information are useful. Now, for the patient, so the budget estimate should not differ too much from ultimately the bill. So I would like very much what is your plan to enhance the price transparency? Thank you. Indeed, we know that price transparency is of great concern to the public, and the bill will empower the Director of Health to specify certain items on which budget estimate should be provided. And we know that we should communicate with the doctors and hospitals on that front. And maybe you can recall that in October last year, through the Hong Kong Private Hospitals Association, we tried to roll out a pilot program for enhancing price transparency. Well, that program was on a sort of voluntary basis. We tried to work out this budget estimate system. We worked on 24 medical procedures initially, and we tried it out for over half a year, and it seems that the pilot program is becoming increasingly more accepted by the doctors, and more doctors are joining the pilot program now. And we know that the insurance sector is also very concerned about this. So in the past several months, I have also talked to the friends from the Federation of Insurers, and we try to listen to their views from the insurance perspective. When we come up with the budget estimate system, how can the work be done better? How can they help? So this is still very much a pilot program, and going forward, we will try to see how the program can be further improved. But when we are working on the bill, in parallel, we try to gain certain experience through this pilot program to see how the program can be improved. We have talked many times to the doctors and hospitals on the details, and the doctors are not so much concerned about the doctors' fees. They are more concerned about the hospital charges. And we have talked to the hospitals and doctors a couple of times, and there has been improvement. Mutual trust has been enhanced, And we don't want to cause nuisance or cause too much inconvenience to doctors, and at the same time we can help patients in giving them better information.
The doctors know how much he's going to charge, but he has to also ascertain the charges and fees of the hospital. Well, if you allow them to choose, of course, they will go for the maximum degree of freedom. But if they don't heed your advice, then, well, you have to make rules when warranted. Well, it's going to be difficult, and they will resist, because hospital fees and charges have always been a problem. We have seen a premium increasing by 10 to 20%, when medical inflation is at a rate much higher than ordinary inflation. We don't want to see a situation whereby patients are diverted back to the public health care center, and we want to make sure that private health care service is of a high quality. It will be meaningless if you don't have any tooth in the regulation system. We'd like to provide a legal basis for the director to require this. The director can issue codes of practice, and the power is also vested by the bill in the director to require certain details be provided. I know it's not easy to come up with a hospital budget estimate. Some hospitals have participated in the pilot. Well, the hospital may set the itemized fees and charges, but the usage is determined by the doctor, the attending doctor. Mr. An Zhang, I heard a question about whether this will cover the beauty centers where doctors are hired to provide services. Do you also cover vet clinics? No.
Okay.
It's either a medical practitioner's clinic or a dentist clinic. Well, I welcome the proposed changes. And they said that the laws have not been amended for a long time, and it's time that we give it a facelift, and we need to make certain clarifications. Mr. Tommy Jones thought that under Mr. Chen Hanban's chairmanship, this bill would be endorsed in one meeting. But I have also heard from Mr. Chan, Dr. Chan, that about Annex B, that there are certain requirements with regard to the Chief Medical Executive. Under clinic, in one of the clinics, you need to have 4 years of experience. Under another category, it's over 10 years. What's the difference between the two categories of clinic? Clinics can be categorized into two. One, a clinic may be operated by an individual. I may also hire a doctor to provide some service. And we are also called the health management organizations, very much like a chain store. They have different branches, different clinic. And then some not-for-profit organization also operate a chain of clinics. If it's managed as a group, they would have a standard management practice applicable to all the clinics under that group. So if we ask them to appoint a chief medical executive for each and every branch clinic, then it may be unrealistic. So we have asked for a lower requirement that is 4 or more years, but the highest number of clinic under this CME's management will be 2. Or they can appoint 1 chief medical executive, but we require a higher standard of experience, that is a 10. And they have to set up a medical advisory committee, very much like a hospital. So if many clinics come under the same group, then we need to have a more experienced doctor as the chief medical executive, and they also have to set up a medical advisory committee. For each clinic, a registered medical practitioner or dentist is appointed to assist the CME. So there are 2 types of clinic. One individually operated, the other operated as a group of clinics. For the second group, that is a group of clinics, and you require a medical advisory committee. It's not in the brief, or is it in this pile of paper?
你見到附件 B 有寫嘅，法例有提啦，即係法例會提啦嚇。個附件 B
It's in the bill and also in Annex B.
咁我想問下呢個醫務管理顧問委員會又係
Who would sit on the medical advisory committee? Mainly doctors. For clinical decisions in the clinic, it must be something done by the doctor concerned. But we also want the medical advisory committee to give advice. The members are independent. What are their powers? Maybe you should read up, Ms. Chang. I can ask Mr. Lee to give a response. Maybe I don't want to hold up other members. Maybe Mr. Lee can provide succinct response. We want to have a body responsible for the governance of the organization. Therefore, we ask them to set up a MAC, Medical Advisory Committee, for each clinic. Then the doctors of different specialties can then sit down and discuss medical practices, whether there are medical incidents, whether there are alarm signs, and also the requirements of doctors that are allowed to practice in their clinics. So if we have a big group of clinics, and if they fulfill certain criteria, they should set up a MAC to improve governance. Their functions will include management of medical services, clinical services. For example, the qualification and other requirements of doctors that would be providing service in the clinic. Such things would come under the ambit of the MAC. And the doctors of the different specialties in that clinic would have to be on this committee. If they have any dentist, and the dentist should also be on the committee, and there should be an external member. A doctor from outside the clinic should also be on this particular MAC. Mr. Tommy Zhang, Chairman. Well, we haven't done this for decades, and now it's a half-baked idea. Paragraph, for example, paragraph 7, you want to introduce transparency. Why do you have to regulate something between the hospital and the patient? Maybe you are too young, and you haven't been haven't much of an experience of hospitalization. Some of the fees and charges of hospitals are really unreasonable. If you are hospitalized for the same operating theater, the same cotton swab, and the same material you use, if you are admitted to a first-class ward, you are charged differently from a patient in a third-class ward. The difference lies in the ward where I sleep at night, during the night. If it's first class, I have to pay more. Well, if it's a hospital, no one would complain because you may also enjoy more spacious accommodation. You enjoy some sea view there. But if you go to the coffee shop there, would you expect the cup of coffee to cost you more if you live in a higher class hotel room? No such thing would be allowed. It's not a question of transparency. Well, it may be transparent, but is it fair? Well, if you have an operation on you, do you also want them to have an operation on your wallet as well? The director is a doctor. He may be doing this for his or her classmates. There are so many doctors protecting one another, and they may have a very complicated relationship lasting over several generations. So I have a very focused question, and that is why does the Hong Kong SAR government allow private hospitals to rip off their patients? Thank you for your questions. I'm also a user of private hospitals. My family have some experience, so you have been lucky. Well, yes, maybe I have been lucky. Under this bill, as in other aspects, we think that we need to handle transparency. I know Mr. Zhang would like us to regulate the fee levels and arrangements. We know in the past, if you are admitted to different classes of beds or wards, then for the same service rendered, you'll be charged differently. We know, but there are different ways of looking at it. But it's difficult, and we are of the view that we should not try to regulate fees and charges. We think we do have a responsibility to ensure the maximum degree of transparency. Apart from transparency, we can also promote package charges. In that, you are not charged according to the quantities of cotton swab you use and the like. And they will tell you upfront what the likely cost of hospitalization will be, and that would promote wider use of private hospitals and private medical practitioners. Well, package fee is a different matter. You can order a meal in my cafe based on the set menu or a la carte. You should ask them to list the charges for different classes of beds. For example, this same piece of cotton swab would cost you this much if you are a first-class bed patient. Well, if I'm about to die, then I'm admitted to a private hospital. I have an operation, and then I lied in an OCU for months, and then I'll have to pay the fees they charge, and I may have lost all my assets.
Should hospitals have all the say? You should not rip me off. Dr. Kokaki has stepped out. Ms. Alice Mack, the second round. Ms. Mack. Chairman, I have two questions. One, I think we should hold a public hearing on this bill because at the panel, we didn't have the chance to hold a public hearing, so we should do so now. And we should invite not just people from the medical sector to come, but also others who might be involved in medical procedures as well, say, for example, the beauty industry. Second, Mr. Son, in his reply to my question, he said, well, I asked him, say, if some beauty centers employ doctors who are doing injections and doing things like those done by the center in the court case now. Now, if the doctor's not being hired there, and whether the center only asks the doctors to come when there is business or a need for the service, so will these centers have to obtain a license as well? And Mr. Chen Kim-po talked about fees. When we regulate private healthcare facilities, you want to regulate their services, of course. Well, there was this court case going on. For this case, we want to pin down on the person in charge. We want to regulate this person, and also we are also covering the hospital or the fee, or the charges of the medical institutions under the bill. But then the bill sounds vague. All it says is that the medical institutions have to provide or have to have transparency in pricing. So can we model after the HKMA? There is a platform set up for all the private hospitals to fill out information on their charges. So if there is this platform, then people can make comparisons. When they try to find out what Hospital A is charging, they can at the same time look at the fees charged by Hospital B. So that can be competition as a result. Can that be done? Another question is related to complaints. Now, the Medical Council has a backlog of complaints. That's a problem. You talk about 24 to 48 members on this committee on complaints. Do you think that that number should be sufficient so that we will not be seeing a repeat of the problem of HKMC? Thank you. I'll answer the question one by one. You referred to beauty centers. You said that doctors employed by beauty centers, that's the case, scenario you mentioned. But if it's not the case, if this doctor sets up a clinic and provides patients, but under our exception arrangement, if we are talking about a clinic with less than 5 doctors, the doctor is a boss and he's not employing other people, then he can ask for exemption. Well, I'm talking about a beauty center, setting up a center, and then if they have a sort of a client coming in, I'm asking the doctor to come over to help. How will you handle that? Now, to reassure members of the public, well, if we're talking about a clinic, the clinic should provide medical procedures, and it should not say provide other services. Now, well, of course, if and some ancillary services can be provided, for example, the OT service. Now, a beauty center can set up a center, but it is allowed to provide medical procedures, but they should have a separate, say, premises for that. What we don't want to see that is that within this beauty center, there is this room in which a doctor is performing some medical procedures. That's not desirable. And if something untoward is happening, then it's very difficult for us to hold somebody responsible. So if a beauty center is not hiring a doctor, does that beauty center need to apply a license? If the beauty center wants to provide medical procedures, it has to get a license. I agree with that. Do you remember that there is this hair transplant center and it is providing liposuction service? Now, if you are providing medical services, you have to obtain a license. So you make sure that there is a separate access for the room providing the medical procedures. That should be an independent service. Now, you mentioned about fees. In terms of price transparency, there are several things that we want to achieve. One is that we want to have a budget estimate system put in place for each patient. And you talked about comparison among hospitals. We have made reference to overseas practices. And they have historical statistics. Now, the hospitals may give you items on individual fees on individual items, but ultimately you still don't know how much you are going to pay. But then if they have historical data statistics, say if you want to have appendix removal and so on, so if we give you the information on, say, some historical statistics on the fees charged on the operation, the median fee, and the say the 19th percentile, the 17th percentile, what is the fee at that level, and so on. So such historical statistic will be very helpful. Singapore has done it for so many years, and that can help patients make comparisons. Say, if I have to undergo a surgery in a hospital, then I will be in a position to know, say, in the past year, the fees charged by the hospital on average. The median fee can be provided, and I can also compare that with that of another hospital. So that's what's being done. Now, we're not covering so many surgeries now, but as time passes, we may include more items and surgeries in that statistics or database. Then people will be able to know better the fees to be expected. You can go online and make comparisons, and then you will know how to ask questions, and you can make more informed decisions. So that can help enhance price transparency and help people to make their choices for PHFs. Can you also answer the question on complaints? It's difficult to estimate the number of complaints in the future, but we want to handle the complaints expeditiously. So that's why we are proposing some 40 members on that committee. And every time there will be a small working group set up for each case, and the DH staff will help with the investigation. We hope to handle the complaints within a reasonable period. Mr. Lang Kwok Hong, you refer to the historical statistics and so on. Will you be providing for that in the bill? Mr. Lang, can you speak into the mic? Are you legislating on this? Or is it going to be, say, an administrative arrangement merely? And that is to ask each hospital to publish historical statistics for reference by patients. Are you covering that in the bill? Did you get that question? Yes, I understand Mr. Lang's question. Yes, is that the right? Yes, we will cover that. And the main ordinance, we will empower the D of H to specify the surgeries or the items where historical statistics have to be provided. We want to enlarge the database gradually. And the main ordinance empowers DHA to specify certain surgeries and private hospitals. And once that have been specified, budget estimate system and historical statistics have to be compiled. So in the current legislative exercise, the Director of Health will be empowered to do this. And as for the codes of practice, that will not be covered under the legislation, is that right? Is also the ordinance which empowers the D of H to issue codes of practice. So the law will empower the D of H to issue code of practice. Well, will the codes of practice be included in the law itself? Yes, I get that. Well, we did mention about codes of practice, but codes of practice are subject to revisions all the time. So when will the codes of practice be submitted to the LegCo for scrutiny? Or is it the case that once we've empowered the D of H to do that, then we don't have a chance to look at the codes of practice? Well, the D of H can issue codes of practice based on the circumstances. I don't think that the approach is desirable. Now, if I give you the power to issue of codes of practice, but then you come up with very bad codes of practice, then that's very undesirable. You may say that that has been the approach adopted all along, but I think this is very undesirable. You talk about historical statistics, you talk about median fees, you talk about fees being made transparent and so on. But what if you can't really achieve all these? Then it will mean that our passing of the bill serves no purpose at all. And I would like to follow up on Ms. Alice Mack's question. So if they say the beauty center hires a doctor, then that center will automatically become a clinic or what? Well, if it hires a doctor, then it provides medical procedures. And then that means that it will fall within the ambit of our regulation. Say if you want to have a slimming process and so on, will that be covered under the bill? If a medical advice is being provided a doctor, then that also means is a medical service, right? A doctor can perform many functions in various capacities. A doctor may be a scholar, and he still is a registered doctor. Say, for example, for a beauty center, it hires a registered medical practitioner with the proper registration. And then the person said that I'm not providing medical service, so to speak. I am just providing input advice, because a doctor can be a scholar. If you go to CUHK or Hong Kong U, a doctor, well, you may find a doctor giving lectures. And so should this doctor be a scholar or a doctor? So does it mean that if a doctor gives lectures on medical knowledge, then a doctor is still speaking in the capacity of a doctor or speaking in the capacity of an academic? Now, say a doctor may provide some service to me on how I should slim down. And so when the doctor does that, does it mean that, well, the center that he's providing that advice will automatically be turned into a clinic? And is he, be in the capacity of a doctor when he's doing that? You said that there should be separate accesses, but the doctor can go from one room to another easily. So this is worries me. Now, if I'm a legislator, then now I may be serving as a legislator here, but if I play, say, a soccer match in a football field, then I am a football player. I'm no longer a legislator. So I'm really raising this for your further thinking. I'm not saying or having a stance one way or another. The role of the doctors may be mixed or may become confused.
The person may be a doctor, but he may not be doing a doctor's job. But that's a very good question. We have given some thought to this issue. I might have put this in a simplistic way. And if a doctor is hired, then I suppose he's hired to do a doctor's job, to provide diagnosis or to offer an opinion on a certain treatment and procedure. But if it's not a beauty center, if I go to a civic center and I give a lecture, then it's different. The bill has provided certain stipulations to exclude things such as public education, lectures, and so on and so forth. So if you are on the football pitch, you are a footballer, you are not a legislator. What about the point about on a code of practice? I'm saying that if we empower the director, then we have no further way to intervene. Well, but they need to revise the codes of practice regularly. If they are put under the bill, maybe it would make revisions and amendments very difficult. Thank you for your question. We have also considered this issue carefully, because the medical science is developing rapidly, and very often we have to discuss with the medical sector, and from time to time we'll need to revise the codes of practice. If it's too complicated, then our concern is that it would be very difficult to revise them on a timely basis. For example, if we have a code of practice on fees and charges, then in order to promote transparency, we certainly come to this council to brief members. Remember in October, when we introduced the pilot scheme, we went to the health services panel to brief members and to invite views from panel members, and then also make improvements after taking on board members' views. Dr. Kwok Kake, I think this bill represents a move in the right direction. The most important function of this bill is to regulate private hospitals and then health management organizations, and now it's not just, it's expanded to cover clinics, small clinics. I've read the bill. For the parts regulating private hospitals, I feel that it's not adequate. For example, in the case referred to by Mr. Chan Chi-Jin, the private hospital refuses to offer service to certain patients, and how can this be regulated? And also, the regulatory system is a system with no public participation. And there's no elected public participation in the governing bodies of HA hospitals. I've talked about this for a long time. We need to have some elected members of those boards, although they may have elected legislators on the board, but they are playing a different role. And now there's no public participation, not on the level of individual hospital boards. And the same is true of private hospitals. If it's run by a church, the church would appoint all the members of the governing board. And also you draw the line at 5 for small clinics. There are more and more doctors working in very much like barristers' chambers. They are not related to each other. They just rent the premises together, especially in areas in districts with high rentals, such as the Central District. They share the waiting room, but between them, let's say there are 10 doctors. They are not subordinating to any one of them. They have different specialties, medicine, surgery, ONG, and so on and so forth. But if they have got more than 5, then they would fall under the scope of the bill, and they would be regulated. So how can you regulate clinical practices? It's a big question mark. I know there are big HMO such as Quality Health, and some insurance companies have also established their own medical clinics. But those doctors are employed, so they work for their bosses. So can we differentiate the two types? Under one, they only share the premises, very much like barristers, and the other will be those under an employment relationship. And also we have to bear in mind that one of the practices that are more incident-prone are the beauty centers. They are not licensed, they are not required to be registered, but of course it may not come under the FHB, it's under the CDB. How can we regulate these beauty centers? They are not regulated from either regulatory systems, because on this side they are not regulated because they are not clinics. On the other, there's no regulation under the law. Well, there's no way they can get away with it if on the premises they are providing medical services involving doctors. They will have to get a license, otherwise heavy penalties can be imposed. You cannot say that this is a beauty center and I provide beauty services as well as medical services. We don't accept that. We require for different entrances to be provided for the two types of service. It's okay, you provide a beauty center, but if you provide medical service, you need to use another entrance, because if there's a complaint, we know that everything that has happened inside will be regulated. We know the license, who the licensee is, who the chief medical executive is. So whatever the development that may be taking place in the beauty center, they will have to get a license for the part offering medical services, and there must be a separate entrance. Of course, if they are a small practice clinic with fewer than 5 doctors, then they may apply for exemption. If they offer simple injection services instead of more complicated such as liposuction, then so we make sure that there is no gap that they can circumvent the regulation. Yes, there are many private medical practitioners coming together to form a big clinic. They share some of the space. But we have talked to them about the scope of exemption under the bill. I've talked to Dr. Pierre Chen a number of times. We need to find the right balance. We talked to doctors many times, and they have actually raised the same points. So we think 5 may be the right balance. This council may agree or disagree, but we think 5 is appropriate. Because in a clinic for which exemption is granted, all the 5 doctors will be responsible for an incident. If there are more than, say, 10 doctors, can you really impute all the responsibility on the 10 odd doctors? Or if it's about political, clinical service, you can go to the medical council. For example, if there's a problem on infection prevention, or if there is a nurse causing the problem, and there are 5 doctors, and we have to pursue the responsibility of all the 5 doctors. But if there are more than 10 doctors, can we do this in respect of more than 10 doctors? So this is what we have proposed after a long process of discussion. We believe this number 5 is the right line to draw. So I can't say it's the only possible one, but we think the doctors should not be affected professionally. If there are many doctors together, and then if there's a complaint, there's an incident, then who should bear the responsibility? If we have a licensee and a chief medical executive, then we know who should bear the responsibility. If it's about medical service, then it's the doctor's concern, and if it's something else, the licensee may have to bear the responsibility. Returning to the question about private hospitals. Private hospitals are private organizations. Under this new bill, the licensee of a private hospital must not be a natural person. It must be a legal person because it's a big organization. In other words, that there must be a board as a licensee. Under the bill, the licensee, that is the board, has to bear the responsibilities of a licensee. Well, whatever you call it, a board, a governing committee, at least there will be an external director, independent director, so that there's some external participation, and not all the members are from the same organizations. Ms. Ann Jiang, paragraph 9, paragraph 10, the licensee may or may not be a doctor. If we have an investor, he has the premises, he can hire a chief medical executive and a number of doctors, and if they comply with certain rules, they can run a hospital, private hospital. It's correct. The licensee may not be a doctor. It's not a necessary, it's not a condition. There may be directors. Can we have a licensee which is a company? Or it can be a natural person. The licensee may or may not be a doctor. the day procedure center, the clinics, the licensee and the CME may be the same person, but hospitals are different because the procedures are complicated and risky, and we do not accept a natural person as a licensee of a private hospital. It must be a legal person.
And also, in a hospital, the licensee and the CME must be separate parties. You allow a licensee to be a limited company, but in paragraph 11, you said that the licensee is wholly responsible for the operation of the facility, including medical incidents, of course. So if we talk about a company limited, I would say $100,000 into that company. Well, how can protection be afforded? If there is major medical blunder, well, how can that cope? How can that amount cope? Thank you, Dr. Chang, for your question. If you are talking about limited company being a licensee, then it's not just about the company, but the board and the board of directors should take the responsibility. Maybe the registered capital is of a small amount, but then if, say, serious offenses have been committed, say if your clinic is not operated properly and the DOHS order that your service be suspended, but then you still go on with your operation secretly, then that's a serious offense, and you are subject not only to a fine but also imprisonment. And the board of directors have to be thrown into jail in that case. So if you are a director of a limited company, then you must understand that you bear a great responsibility. The director is not necessarily a doctor, but then, well, maybe the doctors who have caused the medical blunders, and the licensee is not a doctor. So how is the licensee going to penalize the doctors? I think the provisions in the bill are clear. If the doctors have a problem professionally, so that will be dealt with by the HKMC. And for the licensee, it has a certain responsibilities. You have to appoint a CME. If you don't do that, then you will be running into difficulties. I'm not talking about the licensee, because you said a licensee can be a limited company. But then, if you talk about the board of directors, what are the liabilities of the directors? First, maybe if there is medical blunder, and if a doctor is involved, then the doctor has to appear in front of the medical council. But then the director is not a doctor, so he shouldn't be appearing before the HKMC. But then if he's not a doctor, what is his responsibility? If the licensee is a company, we have to pursue responsibility. We have to pursue the board, and the board is made up of directors. So if there is anything untoward happening, the board of directors have to take certain responsibilities. Now we have to be very clear about this. If the doctors you hire have problems professionally, then that has nothing to do with the licensee. Now, if you want to complain against a doctor, you can go to the HKMC, and if you want to claim compensation, the doctors have a professional indemnity to cover that. But what is the responsibility of the licensee? The licensee has to take certain responsibility. Say, for example, you have to fulfill certain obligations, including hiring the CME. You have to make sure that the system works properly. And also, say, if the DOH has instructed that the clinic should stop operation, then the licensee should do that, or else you will be breaching your responsibilities, which can attract very heavy penalty. So that the provisions in relation to the licensee are very clear. The doctors have their own professional responsibility, and then there may be areas in relation to the management of the clinic which falls under the responsibility of the licensee, and that has been set out clearly in the bill. And we have made all the responsibilities very clear in the bill. We set out clearly your responsibilities as a manager. Now, if there are medical incidents, then I think the doctors concerned will be responsible, and they have professional indemnity to cover them in that regard. So please consider whether the licensee should be an individual or a company limited. Now, if an individual is going to be a licensee, then he will treat the business very seriously, because he will be held liable for whatever goes wrong. Well, if we talk about a licensee being a company, the board of directors of the company have to take responsibility. If you're an individual as a licensee, then of course you have to take responsibility. But if you are the director in the board of directors of a company being the licensee, the directors have to take responsibility. I would like to ask a question about the fourth type, health services establishments. These are to be sort of all-encompassing sort of concept, because that is to provide for encompass new modes of operation or delivery of medical services that entail a significant level of risk. Now, maybe something happens in the future which is not expected today, and every time when something new comes up, we have to amend the legislation, then that is going to be problematic. So we're now empowering the SFH to revise Schedule 8 to cover certain health services establishments in the future. And for Schedule 8 now, we just have one type of institution, and that is academic institutions conducting clinical trials. So is this the only scenario that you can think of now, or is this the only kind of establishment that is in existence in Hong Kong? And what about overseas jurisdictions? Are there any health services establishments or the like in overseas jurisdictions? When we drafted the bill, we have considered that Cap 165 was drafted some time ago. It has a history of, it was drafted in 1930s, a long time ago. So as technology develops, something unexpected may appear. So that's why we come up with this fourth category. And if we do it by a new piece of legislation, then that is going to be cumbersome. So the fourth type can help us to stream down the process. Now, CUHK and HKU are conducting clinical trials. They have research institutes, and they're not hospitals per se. If we regulate them as hospitals, that would be too stringent. But if we don't regulate them, then we are worried. So that's why we put them into Schedule 8, the fourth category. And for the time being, we can't think of any other type of institutions falling under that kind of category. Well, maybe one possible type of institution, we're exploring that idea. The hospice care institutions. They are now hospice care service is provided in hospitals and sometimes in care homes. Now, maybe one day in the future, we want to set up a hospice care hospital, a dedicated hospice care service, and we want to regulate them, but not in the way we want to regulate hospitals. So that will naturally fall into Schedule 8. This may happen. Now, what about cloning of human beings or cloning of reproduction of organs? And if some labs are doing that kind of processes, will they fall within this fourth category? Well, that is too complicated. For fourth category, we will be considering the licensees and how to regulate them and so on. But if we talk about cloning of human beings, that involves not only standards for premises, but also, say, moral standards and so on. So this is something that goes beyond the bill. The bill covers, say, the premises, infection control, licensees, and so on. And what the bill is not dealing with is, say, moral matters, matters relating to human rights and so on. So those fall outside the scope of the bill. If we want to regulate those, we need a new piece of legislation. And I want to ask a question about the DOJ's powers. And it talks about the DOJ not needing a warrant to enter into PHFs, and also the power to enter PHFs on an emergency case without a warrant. Can I defer to the to Mr. Lee? Now, with regard to enforcement power, we have sought the views of the DOJ. I have made separate provisions for those. And Raymond Chan refer to sections 113, 114, and 115. Now, for those not needing a warrant, we are talking about licensed private healthcare facilities. Those are already covered by a license. So for those cases, we can enter into such institutions to observe and to collect evidence on whether the conditions, licensing conditions, have been breached. But then for certain other scenarios, they are not licensed facilities. Say, for example, in a hotel, some medical procedures being performed, and we need to enter into those premises. And for that kind of a scenario, we need to obtain a warrant from the court before we can enter the premises. So that can help safeguard the rights of the people in these private premises. So these are two separate scenarios. But in cases of emergency, where public safety is at stake, whether we can enter a unlicensed private healthcare facility without a warrant. Well, in this section, we set out clearly how that power can be invoked. Well, say if in a ballroom or function room of a hotel, some beauty procedures are being performed, beauty medical procedures are being performed, you can invoke that particular section to enter, right? Well, in that case, we may have to obtain a warrant first before we can enter the premises, because these are not a licensed facility. So what do you mean by emergency cases? In 115, we said that we have the reasonable grounds to suspect that a contravention is being committed, and that the entry into the premises is necessary for protecting public health, and it is not reasonably practicable to obtain a warrant in the circumstances of the case. So the case is really indeed a very urgent one. So this is a kind of a power exercised by the police, or what? Can I defer to Dr. Fong? For the enforcement of Cap 165, we normally enforce the law together with the police. But then for emergencies, I think we still have to further talk and coordinate with the government departments concerned. Well, let's save that till we come to the clause-by-clause scrutiny before we discuss this further. Dr. Chen, I would still like to follow up on the question of hemodialysis. Can the government provide some papers to us on the details of hemodialysis? What are the different considerations you have? I'm sure that the renal experts are very concerned about this, and I would like to have the details and, say, the classifications of the different scenarios, etc. Can I get the papers? I don't know. I'm sure that all of us here don't know how many types of hemodialysis there are, but for a renal doctor, they know very much what are the different types of hemodialysis and how they will be regulated. Are they considered high-risk procedures or what? So I need more information before I can discuss this with you further. Somebody mentioned about beauty procedures. Say if a beauty company wants to perform medical procedures, maybe they do it in another room with another entrance. So my question is, how does the government define medical procedures? I want some papers. What do you consider as medical procedures? I hope that I have heard you wrong. Well, you said that as long as a doctor is performing the procedure, then that's considered a medical procedure. If not, then that's not considered. I don't agree with that. Well, maybe you don't. You can't answer my question, but give me something in black and white. What do you mean by medical procedures? What's your definition of that?
And what do you mean by practicing medicine? Some doctors may be providing details. Do you have any requirements on the qualification on nurses running the clinic? And I also want to get something in writing concerning these requirements. Thank you, Dr. Chen, for your question. It's not just about renal services. Every service in the schedule has been discussed by the expert groups. All the documents have been circulated to doctors. I can ask Dr. Feng to explain, and I believe that those papers have already been issued. We can, of course, provide the same to Dr. Chen. As regards whether there's any requirement on the nurses, let me add a point. I haven't been able to find the doctors. I must say I read the papers very meticulously. It's okay that you give me the papers after the meeting, but I believe that, well, I have never received the papers that you have been talking about. But we'd like to involve the doctors. As for what constitutes a medical service, there's a definition. Of course, it's not as simple as saying that whenever there's a doctor, it's a medical service. Maybe as Mr. Leung Kwok-hong has put it, if he's doing some public education in the form of a lecture, it's not. But if he's carrying out some medical procedure, then it is medical service. We don't have an itemized definition in the bill. In the steering committee, before we had this bill, it was very comprehensively considered. Because of the advancing medical science, it's difficult to itemize different services. But of course, we can talk about the principles, the concept, and we have a definition which is based on broad principles. So we have a definition on the medical service in the bill, but of course I can provide the required information to Dr. Chen after the meeting. On hemodialysis, Dr. Chen is correct. There are different types. When we had the discussion with nephrologists, we talk about a number of procedures, renal or hemodialysis procedures, which are more risky, and they have to be done in a hospital and not a day procedure center or clinic. So risky hemodialysis procedures have to be carried out in a hospital, and we will provide a more detailed definitions We will provide clear descriptions on what can be done in a day procedure center and what can only be carried out in a hospital. Where can we find them? Mainly, we separate the procedures that can be carried out in a clinic vis-a-vis a daycare procedure. And there are many procedures that can only be carried out in a hospital. We need to talk to the medical colleges and the relevant sector. And we may also provide more details in a code of practice. And medical procedures are developing very rapidly. So it's better that we provide the details in code of practice, but we consult the practitioners. There's no provision in the bill on whether nurses should be hired or under what circumstances. But that depends on the service needs. In a hospital, for different procedures and different specialties, they need a different complement of nursing staff. We expect that it would be services would be for the clinic standards. We have 7 to 8 different procedures for daycare centers. After the discussion of the working group, if there's a need to specify that nurses should be hired for certain procedures, that would be listed under the standards required of certain premises. Dr. Kwok Ka-Kay. I want to ask a follow-up question with regard to the point made by the head, Mr. Sun. Well, you need to specify a number, and 5 may be appropriate, but we need to differentiate two different operations, two modes of operations. One is running a clinic, and the doctors co-own the clinic. You mentioned the sharing of the pharmacy, and in some cases, they don't even share the same pharmacy, and every doctor would be doing the prescription individually. They may share the X-ray machine or the waiting room, and they do the dispensing of medicine themselves. Well, if they have various specialties, so for example, if they treat patients with lupus, then they have special medicines to dispense. I know that the number cannot be very clear-cut. But some of them are working as a group. Some of the doctors are employed to work in the clinic, and they have common interests in the operation of the clinic. So we need to regulate the practice irrespective of the number of doctors there. You want to have an external member sitting on the governing board. Maybe we can consider appointing a district councillor to the relevant board if the councillor is familiar with the location of the private hospital. And as chairman, are we going to have a public hearing? There are many stakeholders. I don't know how much time will be needed for the public hearing. well, not in the short term, because the summer recess is upon us, and we need to get a quorum. All right, maybe we can consider this after the summer break. Would you be willing to do some consultation during the summer break?
正如啱啱我所講咧，就係我明白。
As I've said, well, I understand that some private medical practitioners are sharing some accommodation, some premises. In the majority of cases, they will be doing things on their own, but they also share something. In the drafting of the law, we have had a very detailed discussion with them. Up to this point, we haven't been able to come up with a good way to distinguish the different modes of operation, because we need to answer this question from the public. If there's a problem, a medical incident involving the clinic, what are we going to do with all the doctors? So we can only say that the number should not be too big. The number of doctors should not be too big. When we draw the line, well, we have been communicating with doctors. We have had more than 70 briefing sessions. We pay visit to different groups, and we have had discussions in various formats. We know that this bill would touch on the modus operandi of different doctors and clinics, and if necessary, we would rather stay away and not intervene. But for public safety's consideration, we need to do what we should do. We would like to engage electrical members to see how we can introduce an appropriate regulation system. As for the board membership, we cannot really mandate that certain members should come from certain sectors, because these are private hospitals, private organizations. So we are saying that there must be at least an independent external director, so that the board will not be composed of their own people and no one else. The licensee may not be a doctor. So it's clearly provided in the bill that from medical affairs, they need to engage a CME, so that if there is a problem, the Hong Kong Medical Council can be involved. So the professional practice of doctors will be regulated by his peers, i.e. other doctors. Ms. N. Zhang, I don't want to be brought down by the problems related to the licensee and the CME, because the licensee shoulders heavy responsibility according to paragraph 11. You may license an ABC Medical Center. The license is given to ABC Medical Center. Under this ABC Medical Center, you have the licensee and the CME, Chief Medical Executive. So you have a dual head system. If the licensee is not a person, it's a company, then it's a big loophole. The licensee may not be the investor, because under this ABC Medical Center, you have an investors. I'm a director of that company holding ABC Medical Center, and this person and his friends are interested in running a clinic, and they have invested $10 million in setting up this clinic. So this is my suggestion. That person should shoulder certain responsibilities. I hope you will consider this, because that may involve the need to introduce amendments to the bill. On complaint management system, let's not talk about the first tier. The first tier means that you lodge your complaint with these relevant PHF. There's a second tier, an independent committee on complaints against private healthcare facilities.
And there will be, you will appoint a chairperson, a deputy chairperson, as well as 24 to 48 other members. And I'm pleased to see the sentence, at least half of them being neither registered medical practitioners nor registered dentists. They are some external members. And I think this will be accepted by the general public. And for this committee on complaints, well, there'll be overlapping of its work with that of the Hong Kong Medical Council. Say if the clinic or the medical center has a medical incident, can the person concerned lodge a complaint with this committee and at the same time with the Hong Kong Medical Council? This is a very good question. The terms of reference of all the functions of the two are different. If it has to do with the professional misconduct of a doctor, then you will lodge a complaint against the person, the doctor or dentist, with the medical council or the dental council, respectively. Now, for the Committee on Complaints, it will deal with matters covered by the bill. Say, we say that there should be a budget estimate, but then that's not done properly, then a complaint may be lodged. And sometimes it has to do with the service attitude of the staff, or maybe there may be problems in the operation of the dispensaries. Maybe there is a problem with the manpower, and all these do not have anything to do with the professional judgment of doctors, but rather with the operations of the hospitals or the clinics. And maybe they have to do with the service attitude, payment, etc. So these matters can be brought to the Committee on Complaints. But then, despite this, in the course of investigation, maybe the professionalism of the doctors or the dentists are found to be involved. Maybe the complaints don't start out with complaint in that regard, but in the course of investigation, such issues are found to be of relevance. Maybe if that happens, this committee can refer to the cases to the HKMC and also the Dental Council. We will not ask the complainant to lodge a complaint afresh again with the other bodies. A reasonable approach is that if in the course of investigation we found that issues involving the other two investigative bodies appear, then the cases will be referred to these two other bodies. So there is a division of work among the three, and then there should also be sometimes interface among the three. So that means that the complainant can lodge a complaint with both parties or both bodies, right? Yes. Well, we won't stop complainants from doing that. They can lodge a complaint with both at the same time. The Committee on Complaints deals mainly with complaints against private healthcare facilities. Well, I think doctors are naturally involved in the complaints, I would say. I don't think people mind about paying, say, $200 or $300 more. I think they would probably complain about medical problems, medical incidents. So can we consider that? Maybe come up with a table listing out all the different cases to be handled by the different bodies. And do you also would set a limit to the time for complaint? Say if they don't get a reply from the first tier mechanism, so can they get to the second tier, say by a certain date? Yes, there is a time limit. Thank you, Dr. Zhang, for your question. For this two-tier complaint system, we want to encourage the PHF to deal with their complaints as far as possible. And if that case is handled at the first tier, but then is not going anywhere, the complainant then can submit the case to the second tier Committee on Complaints for handling. Maybe the complainant doesn't, comes directly to the Committee on Complaints without going through the first tier. And the committee maybe will go back to the first tier, the PHF concerned, to see whether they can deal with it first. We'll try to really implement the two-tier system properly. So there is no deadline, so to speak, as to on when the complainant should lodge the complaint with the second tier complaint committee. All right, Dr. Zhang. Paragraph 9 of the paper states that the public was consulted on and widely supported the regulation of the first three types of PHFs. Have you consulted the doctors on top of the public, and what are the doctors' concerns? Yes, the public includes doctors as well, but we understand that we just should not just rely on the views of the public and the doctors. And in fact, we've done extensive consultation among the doctors, including visiting the doctors. Well, we have done, we have organized over 70 visits. We organized large-scale briefing sessions attended by several hundred doctors in each session, and we have written to every doctor and every dentist and telling them the important provisions in the bill. And also we have the expert committee under the HKAM, and if the experts or specialists were not happy, they would come to me directly, and we've met with the ophthalmologist and also nephrologists, and we have had many meetings and have detailed discussions. What doctors are most concerned about is the standards on the premises. And they are concerned about the standards of facilities to be drawn up by the D of H in the future. And we need more discussions with the specialists. We will not just work on the standards on our own. We have to discuss with the specialists to make sure that they found that the proposed standards are reasonable, will take reference from overseas practices. So the doctors are most concerned about the standards of the facilities, but we do have an established mechanism, and if they are unhappy with certain proposals, they can reflect the same to us. And also we have 7 expert committees under the HKAM. Well, hospitals are all right because they are already subject to certain standards. And the greatest challenge lies in day procedure centers. And there are 7 types of day procedure centers under the bill, and they've never been subject to any regulation before. So we understand the great challenge lying ahead. And we have done a lot to try to listen to their views. I don't think there are major problems. It's a matter of thrashing out the details now. How many day procedure centers will be affected? How many will come forth to make an application for a license? The DOH has done 2 surveys, and according to the survey results, as far as the day procedure centers which are performing high-risk medical procedures, there are 500 of them. All of them have to obtain a license because they are performing high-risk procedures. But for general clinics, they are not. They are just having simple vaccinations and so on. And there are around 5,000 such clinics. And they don't have to, not all of them have to obtain a license. So for those who just have fewer than 5 doctors and they are operating on their own, they can get exemption. And among the 5,000, 70% may be qualified for exemption. Well, but of course, it's up to them as to whether they would like to apply for exemption. They might like to opt for obtaining a license. So it's really up to them to make a decision as to whether they want to obtain a license. I've met so many doctors. Some of them actually told me that they want to get a license. So around 3,000 out of the 5,000 are eligible for exemption. Now, say if 3 or 4 doctors band themselves together and rent premises to run their business, why would they opt for obtaining a license or opt for exemption? What are the considerations? We will hold a public hearing today. Well, leave me several minutes so that I can handle the business that I want to handle. This bill, the law has to be amended because it was drawn up first in the 1960s, and we have done consultation for a number of years, and the bill has now been drawn up, and so far we haven't held any public hearings or done any consultation on this bill, and some members have asked for a public hearing to be held. I would like to do that. But we're coming to the end of this session, and we need a quorum to hold a meeting. So we also have to give sufficient notice to organization, individuals, etc. And very possibly we'll have to hold the public hearing a little bit later. And the bill is also rather lengthy. I would like to have the public hearing first before we go to the clause-by-clause scrutiny of the bill. Maybe after the meeting, I can work together with the Secretariat and the government to identify a good time slot for holding a public hearing. We've got 2 minutes left now, and I'd like to thank the fellow members and the administration for attending the meeting. Meeting adjourned.